We are going to let in our participants. All right. Good afternoon, everyone, and thank you all for joining us for today's monthly service presentation of evictions and knowing your rights. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and joining us, we have Ms. Cecile Carlson. Also, in addition to that, our presenting partner on behalf of Lone Star Legal Aid, we have Ms. Kimberly DK, who's going to be providing the information to you all today about evictions and your rights. Also included in our partnership, we have the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, the Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up a month of service. And basically, a month of service is the collaboration of all of our organizations coming together on a monthly basis to offer a variety of different workshops, resources, and information to the community relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. We know that there are a lot of underserved communities that are out there that don't have access to a lot of resources or don't know where to go for particular resources. So we decided to collaborate several years ago in an effort to reach more people, to create a larger impact, and to get as much information out to the community as we possibly can, considering we do serve the same community already. We thought it would be a great idea in order for us to do that. So this collaboration has evolved with the workshops that we've offered over the last several years. We used to be in person doing these types of presentations, but of course, we had to transition to the virtual platform. And this has allowed us the opportunity, in all actuality, to reach even more people outside of the city of Houston, but also throughout the county, throughout surrounding counties, and even across the state of Texas, providing the information that we have to share. Do know that any of our legal service presentations that are offered are relative to the entire state of Texas. Is not just for the city of Houston. The law does apply to the state. So regardless of where you're joining us from, know that the information is relative to you as well. In addition to that, the information that does get provided is for educational purposes only. It is not to be considered any legal advice. However, we do encourage you to reach out to our legal service partners like Lone Star Legal Aid if you do find yourselves in need of any civil legal assistance, or if you find yourself, in this particular case, facing eviction and you need legal assistance in regards to that. So Ms. DK is kind of going to go over some other information about the other services that are also offered at Lone Star as well. So with that being said, this is your opportunity to ask questions that any questions that you do have. However, we do want you to keep in mind that we are on a public forum, that we are also recording the session as well as broadcasting live on our social media, on YouTube, as well as sharing it on Facebook and Instagram. So we do ask that you try to keep your questions to be as general as you possibly can. We want to try to protect your privacy as much as we can. So we don't want to divulge any personal detailed information about your particular circumstance. So we do ask that you just try to keep your questions to be general in nature. So don't say that, you live at ABC and you're renting from XYZ, that kind of thing. We don't want your personal information out there again. So do have the opportunity to either type your questions into the chat, or you can wait until the end of the presentation and unmute yourself and ask your questions directly of Ms. DK. In addition to that, if you are joining us on social media, please feel free to type your question into the comment section, and I'll make sure that your question is read aloud and addressed at the end of the presentation as well. So on behalf of the month of service, I want to thank you guys for joining us this afternoon. And we're going to get right on into our introductions and into our presentation. So Ms. Cecile, we're going to have you introduce first, and then Kimberly, we can have you go and then move right on in.
Sure thing, Nia. Thank you so much for the introduction. Good evening, or good afternoon, everybody. Thank you all so much for being here. My name is Cecile Carlson. I'm the outreach coordinator with the Office of Neighborhood Engagement as part of the Department of Neighborhoods. And like Nia mentioned, we are one of the partners that collaborate through a month of service. We're very thankful that you guys are here today. We're thankful to our partners for this presentation. And a lot of us are renters or no renters. So this is really good information for us to keep in mind, to share with the people around us, and to ask the important questions while we have the experts available here. So thank you so much to everybody, and I'll pass it on to Ms. DK.
Okay.
Hello. Let me go ahead and start sharing my screen. My name is Kimberly DK, like they stated. I'm a staff attorney with Lone Star Legal Aid. I work in our eviction right to counsel unit. I've been working in this unit for about 5 years now through the pandemic, and each year we learn something new. So we're happy to be here and provide information. So Lone Star Legal Aid, to begin, is a 501c3 nonprofit law firm with a rich and deeply respected history of advocacy on behalf of low-income and underserved populations, beginning with the Houston Legal Aid Clinic in 1948 and East Texas Legal Services in 1977. In order for us to help, you must go through an application process. You can apply 24 hours a day and 7 days a week by applying online. You can also apply by calling the toll-free number listed for the office that serves you. Each Lone Star Legal Aid office has a designated time for non-emergency applications taken over the phone. That needs to be updated, but we are currently scheduling in-person applications and appointments. Lone Star Legal Aid does serve about 72 counties in the southeast area of Texas. So please, even if you are in a rural area, feel free to look up and see what office is near you, because more than likely there is one. Otherwise, of course, if you're in Houston, call our toll-free number. And you can also apply online at www.lonestarlegal.org. As we move into this presentation, we're going to start with first things first, leases. We'll talk about terminating the lease, the notice to vacate necessary for the different types of terminations. Then we'll get into the forcible detainer suits or evictions, appeals, public housing and subsidized housing cases, lockouts and utility shutoffs, what to do when you're dealing with those, and security deposits. All the information we give here today is just for informational purposes and for educational purposes. We are not giving any legal advice right now. So first things first, leases. Texas allows for both verbal or oral and written leases. A lease is an agreement between a landlord and a tenant that establishes the rules regarding the use and occupancy of a dwelling. If the lease term is for longer than a year, the agreement must be in writing, and your lease is a contract. So as I said, a lease is an agreement between a landlord and a tenant and establishes the rules regarding use and occupancy of a dwelling. So for example, like a verbal lease would be, you're gonna live here for 3 months, you're gonna pay $500 a month, and then you're gonna move out. Something as simple as that could be considered a verbal lease. So, but if it is going to be an agreement for longer than a year, it must be in writing to be enforceable. And you have a right to the copy of your lease. This is in the Texas Property Code. So within 3 days of the lease being signed by all parties, the landlord must provide you with at least one complete copy of the lease. If you don't receive a copy of your complete lease, ask for it in writing. So you'll want to send your landlord either an email or write them a letter letting them know you want a copy of your lease and all the addendums, and they have 3 days to give you a copy. And you're going to want to get that copy, review it, we'll go that in a second, and take note of the important sections that you need to know. Some of those terms that you need to know, read over, and make sure you're very familiar with them are listed here. To begin, you'll want to know what your monthly rent is, when and where to make payments, if late fees will be assessed or insufficient funds fees. You'll want to know how much those are, when they will be assessed, how payments are applied. So if you have rent, amenity fees, for example, trash, or any other fees, or utilities on your lease, on your ledger, and you pay just the monthly rent, your landlord can decide through your lease how those payments are applied. So you'll want to know exactly that, because what you think you're paying rent and you're like, oh, I'll pay utilities later, you may not be in control of how your landlord applies those amounts. You'll want to also keep in mind of your initial lease term. That means if your lease is going to be 6 months, 7 months, 12, 13, 14 months, you'll want to know exactly how long that is, when the beginning and when the end is, because you'll see soon that those dates do matter. And you'll also want to know what the terms are if you do have a month-to-month clause. If your lease rolls over into an automatic month-to-month, is that going to be additional fees? Is there a month-to-month fee? Is there a percentage of the rent that it will automatically go up? You'll definitely want to know that so that you're aware of that. And we'll go into other timelines of why that's important to know. You'll want to note your community rules and policies. If there is an amount of guests you can have, if there's a way that you can use the pool or the leasing office, you'll definitely want to understand those, because any number of violations might lend itself to being a reason for an eviction in the future. Any signed addendums, especially if you're on housing, you'll definitely want to take a look at that, see what your landlord is required to give you or what you're required to give your landlord. You'll definitely want to keep a copy of all of those. And if you sign for any concessions, example, if there's any move-in specials that if you default on your lease might end up with additional fees, you'll definitely want to keep note of that. Your acts of default, so the things that could cause your lease to be terminated. For example, failure to pay rent, material breaches of the lease, early termination, which is termination in the initial lease term, or holding over after the initial lease term. Those are examples of what might be considered acts of default that lead to notices to vacate. Another set of information you'll want to know is your timeline. So notice of your lease renewal or non-renewal. How long your landlord must give you if they're going to give you a notice to vacate, or like notice of default if you do break a community rule. How should that notice be given to you? How do you have a time to cure? All of that's going to be important. I do want to touch back on the lease renewal or non-renewal, because after the initial lease term, you'll want to know how soon you need to let your landlord know if you're going to stay or if you're going to leave. So that, of course, you can avoid any fees, for example, if you do want to leave. So after the initial lease term, both the landlord and a tenant have the right to terminate the lease with proper notice per the timelines agreed to in the lease. So like we said, the notice of lease termination or non-renewal, your lease will contain language regarding the timeline of termination and when notices must be provided by either party. Sometimes it's 30 days, 60 days. You'll want to know exactly when that is so that both you and the landlord can abide by that timeline. Because if you fail to leave after the termination date, that makes you a holdover tenant and subject to an eviction. Also, if you don't provide certain notices before the end of your initial lease term, you might end up having to pay a month-to-month fee or a month-to-month rent increase for failure to provide notice. So you'll definitely want to understand that. Except in very special circumstances, you cannot make your landlord renew your lease, just like your landlord cannot make you stay and renew your lease. Terminating the lease during the initial term is deemed an early termination of the lease, and terminating the lease during the initial term without consent may subject the tenant to certain fees and penalties. So like I mentioned, a lease is a contract. So both parties can decide to terminate the contract and waive any fees. You can agree to anything as long as it's in writing. So, however, if you make any decisions unilaterally by yourself, which is without consent, you may be subject to certain fees and penalties. So you definitely want to keep that in mind and make sure you discuss with your landlord anything that wants to terminate or end your relationship during that initial lease term. Now, you do have a right to early termination in specific circumstances. You can terminate the lease and avoid certain liabilities. Your lease may also be required to give notice of these statutory rights. So you'll want to look in your lease and see and make note of the Texas property codes that you'll have to look. I'm going to touch on some of them. I'm not going to go into too much detail. They're kind of self-explanatory. But in order to terminate your lease, vacate the premises, and avoid liability, you'll want to review each statute that I name above. Each one will tell you what documentation needs to be provided to the landlord and what that timeline looks like in order to be able to move out of that residence and avoid any type of penalties. So, for example, if there's family violence on the property or certain sex offenses or stalking, you might be able to provide information to your landlord to move out and get out of that situation and avoid future liabilities. If if a tenant passed away during their lease term, you just provide that information to avoid future liability. However, past due obligations, so if there's any unpaid rent or fees, utilities, or any damage beyond wear and tear, those may still be recoverable by the landlord against the estate. Notice that this information is not required in the lease. However, it is in the Texas Property Code. And then other situations related to military service. You can look up that Texas Property Code to see what information you need to get to your landlord if you're going to be deployed or stationed somewhere else and you'll need to terminate your lease. Other situations where you might have a right to terminate your lease is if you have a casualty loss, which we live in Houston. Even though this applies to all of Texas, we're a wet city. And so you might end up in a situation where a hurricane might have come through and made the premises unusable in some way, shape, or form. Now, if the premises is made totally unusable for the residential purposes due to a casualty loss, and the loss is not the result of the tenant's fault or negligence, then the Texas Property Code 92.054 provides tenants with the right to terminate the lease. Also in that section, landlords have the right to terminate the lease once the property becomes totally unusable as well. If the premises are made partially unusable for residential purposes due to a casualty loss, and the loss is not the result of the tenant's fault or negligence, then Texas Property Code 92.054 Section C provides that the tenant has a right to petition certain courts for a reduction in rent. So that means if you'll put that information in front of the judge and the judge will decide, okay, you have 2 rooms and a bathroom. That's only about 50% of your 2-bed, 2-bath. We can reduce the rent. Now, remember, you do have to petition certain courts to do this. This is not a decision you can make on your own. A landlord, however, does not have the right to terminate the lease just because the premises is made partially unusable. So definitely keep that in mind. However, these options may be waived or altered by the lease. So you'll want to make sure if there's anything, if you know you're in a flood zone or something like that, you'll definitely want to make sure you look and see what you and your landlord have agreed to in your lease. Now, there's the lease can also be terminated because there's a breach or a default has occurred. This is usually what leads to an eviction. So a breach of the lease is any violation of the lease terms, conditions, rules, or other provisions. So your lease will tell you what a breach is. Common default by resident terms that are listed in a lease are failure to pay rent by the date stated in the lease, repeated violations of community policies, unauthorized tenants, criminal activity by tenants, your occupants or guests, or holding over past the initial lease term. If a breach of the lease occurs, the landlord must provide proper notice before filing an eviction. So here's where we talk about withholding rent. Just don't do it. In certain circumstances, this may seem like a good idea, but it is a self-help remedy that is very rarely done correctly and will set you up for an eviction lawsuit. Long story short, don't do it. Texas law requires that rent be paid in full and on time as it comes due. So withholding the rent prematurely could subject you to an eviction based on non-payment of rent. So there might be pests, there might be repairs. Like I said, there might be a partial, you can't use partially unusable space in your apartment. All that still has to go through a process before you can just withhold rent. And also you must be current on your rent in order to maintain many of your rights. So once you fall behind on rent, whether it's on purpose or just, things happen and you're unable to pay your full rent, your landlord does not have to fix anything in your apartment, for example. So failure to stay current on your rent directly impacts any argument you may have to withhold your rent. So until you've gone through the process, for example, if you're having issues obtaining repairs required under the lease or that threaten the health and safety of an ordinary tenant, Send your landlord a request in writing telling them exactly what the problems are via certified mail, and then contact a legal professional. Because after that letter is sent, there are still timelines and other documentation that must be presented, and then possibly a lawsuit filed before you can obtain your right to withhold rent. So it's best to contact a professional to help you through it. And just be aware that it may lead to an eviction even if you feel like you have a reason to withhold rent, just don't do it. Contact us, contact your nearest attorney or organization to help you with that. So, in special cases, what if full and timely tendered rent is refused? So your landlord is not free to refuse properly tendered rent pursuant to a lease agreement. Now, note that landlords may refuse rent if it's late, if it's only a partial payment, or if the lease has been terminated. And like we said earlier, landlords may also determine the manner in which amounts are paid. So if your lease says that your rent is due on the 1st, it'll be accepted through the 3rd as long as it's given in money order, in the office, or via the portal. If you go to pay that rent in the office, money order, or via the portal, and you're locked out for no reason, you have the full amount that your ledger is asking for, your landlord is not free to refuse that, because per the lease agreement, that's what he said. If he or she said, if I stay in the unit, you accept my rent, there should be no issue. Now, if you do run into an issue, tenants who have had timely rent refused should do the following. You want to review your lease and current ledger to ensure that the amount you offered covers the rent and all fees due, and that the payment is offered in a manner consistent with the lease. That's what I was saying about if it's due before the 3rd in a certain manner, and that's what you're doing. You want to document the date and manner of the payments, document your correspondence with the landlord. If you send an email or text saying, hey, I'm locked out of the portal, or hey, my Zelle payment isn't going through, what's going on? You want to make sure you have all that in writing, keep it documented. Keep the payment or the funds available. You do not want to spend the money just because your landlord is refusing it. They are not allowed to. So in the event that you get in a situation where you sue and they need to accept it, you need to have the money, correct? So you want to continue to offer rent in full and on time for the future months, and definitely contact an attorney for assistance. There may be a breach on the landlord side that causes us to enforce the lease. There may be a breach on the landlord side that causes us to terminate the lease. It all just depends on the facts, but if your landlord is trying to refuse payments that are being properly offered, then you definitely want to talk to an attorney before it turns around and ends up with you facing an eviction fairly. So in order to begin the eviction process, proper written notice is required. This is going to be the notice to vacate. Texas Property Code requires proper delivery of the notice to vacate, and this is in the Texas Property Code 24.005. The notice must be in writing, and it must give at least 3 days notice, unless the lease allows for a shorter period. So another thing to note, some might be a 24-hour notice, some might be a 10-day notice. You definitely want to check your lease and make sure you understand that, and make note of that when you receive a notice to vacate. Proper delivery is in person or hand delivered, which means eye to eye, an agent gave you a sheet of paper, or a maintenance man or the property manager gave you the sheet of paper, and and this is your notice to vacate. That's in person, hand delivered. Your landlord can also serve you by putting the notice to vacate in the regular mail, registered certified mail, return receipt requested, or they can post it to the inside of your front door. As an alternative, your landlord does have the ability to put the notice to vacate in an envelope affixed to the outside of your front door. If you do receive notice this way, I encourage you to take a picture of it before you take it down. The landlord must prove up what circumstance would have led them to decide to put it on the outside of your door. And they also must mail a copy by placing it in the mail before 5 p.m. on the same day. So all of those things must be proven up in court. So how you receive the notice to vacate, take good notice of. If you receive it, and you were posted on your door, take a picture, keep a note of it, note it in your calendar. These things do matter in the future. Now, under the CARES Act, covered properties are required to give a 30-day notice to vacate. So even if your lease says 24 hours, 10 days, or or you can just go by the Texas property that says 3 days. If the property is a covered property under the CARES Act, they are required to give you a 30-day notice to vacate. So what's a covered property? A covered property is one that participates in a covered housing program under VAWA, which is the Violence Against Women Act. This is not an exhaustive list, but this means that the property gets some sort of federal backing or federal funding. So public housing, Section 8 housing choice voucher programs, project-based housing, rapid rehousing, low-income housing tax credit properties. Those would all be considered covered properties. So if you know your landlord participates in one of those programs, they are required to give you a 30-day notice to vacate. If they have a federally backed mortgage, for example, if they have a Fannie Mae, Freddie Mac, FHA, or VA mortgage, they also are considered a covered property. That's a little bit harder to find these days, but that can be, other than checking the real property records, you can request that information through the discovery process. And as a covered property, this includes single-family homes, duplexes, mobile homes. If they fall under any of those programs, get federal funding, or have a federally backed mortgage, then they are a covered property required to give you 30 days notice. So evictions, the forcible detainer suit. An eviction's primary focus is to deal with the right to possession of the property. So the eviction itself says, I want this property. Who has superior right to get the unit, the house, the mobile home? If it's me, the owner, the plaintiff landlord has to prove that they are the owner. They have to prove that a breach of the lease occurred, whether that's a lease violation on payment of rent, termination at the end of the lease, holding over. They have to be able to prove up those grounds. They need to provide proper notice that we went over before under Texas Property Code 24.005. And they also have to prove that at the time of filing that the defendant refused to leave. So pay attention to the date the eviction lawsuit was filed. Had you already moved out? Was it before your deadline? All of those things matter. In the case that the landlord is not just asking for possession, they also have the grounds that outstanding rent is due. They can add a claim for the back due rent amounts. However, the landlord can only ask for base rent. So if your rent is $1,000, then you owe $1,000 times 1 month, 2 months, 3 months, however much that is. So because of that, you want to be very aware that what you get in a citation might be different than what the landlord's ledger states. Your landlord under the lease can ask for late fees, past due utilities, and other sums due. They can ask you to clear your ledger in order to stay in the unit. However, they can only ask for base rent when they are asking for it through an eviction. If they want to recover all those other amounts, they do have to file a small claim suit. And you do have a right to a jury trial, even in an eviction. Just you have to make your request timely and the fee must be paid. So you'll definitely want to check your local rules and talk to your courthouse if that's an avenue you want to take. So trial and justice courts. Justice courts use simplified procedural rules and do not have to follow the rules of evidence. They are not a court of record. So the rules differ greatly from court to court. But these are a few things that never change that you'll want to take note of. You want to arrive on time and have everything you might need for trial. Some courts will call dockets, so they might start the day calling everybody at once, while others will have you check in with the clerk or call the cases one by one. Some judges may give instructions before they start their docket on how the court works and other procedures. Others may not. But at trial, during trial, judges will begin with hearing the plaintiff's case first before giving you, the tenant or the defendant, an opportunity to respond. So definitely want to pay attention to what your landlord's saying. That's not a time to tune out. You definitely want to listen to what they're saying, what they're testifying to, based on the things we said that they have to prove up. And you want to be able to not only answer the judge's questions and provide evidence for your defense, but you also want to be able to know and respond to what your landlord's saying, whether true or something that you might have a witness or other testimony to provide to counter it. Trial can only be reset by motion of the plaintiff or if both the parties agree to a continuance. So if you go in front of the judge and you say, I just need 2 weeks, I just need 3 weeks, the judge might not be able to give that to you. It can only be, they are barred from doing those type of resets unless it's something you guys agree to, or if the plaintiff says himself or herself, I want to reset this for 3 weeks to give my tenant a chance to do X, Y, and Z. So just be aware of that before you go to the judge, so that we also say that so that you understand to speak to your landlord or their landlord representative as early as you can, so that if they do want to agree to a continuance or do want to agree to a reset, you're not waiting to get, heard by the judge first. You can kind of deal with that ahead of time and possibly enter a settlement. At the end of trial, the judge will issue a judgment in favor of one party or the other, or dismiss the case. Always get a copy of the judgment for review and for your files. This is another area where courts might differ. Some courts might give you a judgment or dismissal at that time while you're still in court. Others, and then also mail it. They'll also mail it. Some may just mail it, but these things are available online as well, for you to look up and grab a copy. You can also contact the courthouse in return to get a copy. And as always be respectful to the judge, the court staff, and the opposite party. It is adversarial in nature. However, we still want to have positive and polite behavior when we're in the court. So keep that in mind. So, as we're saying, settlement agreements. Some judges encourage settlements between the parties, and they may also provide resources to facilitate settlements, such as standard settlement forms, or even having mediators in the courtrooms during their eviction dockets. A settlement agreement requires both parties to agree to specific terms, although the parties determine what those terms are. So you never want to feel like you can't say no, or that you can't ask for more. The worst they can say is no. But a good agreement will clearly define the actions to be taken by both parties. For example, the tenant agrees to leave by a specific date, and the landlord agrees to dismiss the case if the tenant moves out. And if the court provides a standard agreement, always review to make sure it reflects what the parties negotiated. So even if you get a standard template from the court, you can scribble on it. As long as it's agreements made by both parties and it's signed, it'll go. So don't be afraid to write in the margins, cross things out, because again, it's an agreement for both parties. It can say whatever you guys want it to say in order to help the process move forward and to get both parties, what they need. A settlement, though, must be in writing, signed by both parties, and it should be filed with the court. An informal or unwritten agreement between the parties is not enforceable by the court. We end up just back in trial with a he said, she said situation. So you definitely want to get that in writing, signed by both parties, and filed if possible. A settlement may involve parties giving up rights and may impose penalties if a party fails to comply with the agreement. So if you, for example, fail to move out, you might have to deal with a default judgment. So you'll definitely want to know what you're giving up and what those penalties might be if you don't comply. Always, always, always know what you're agreeing to before signing the agreement, and make sure that you will be able to comply with the agreement before signing so that you don't suffer any penalties. Now, after the court date, if you are unsuccessful, you do have access to the appeals process. Within 5 days of the court date, you can request an inability to afford court costs and fees form. We call it an IFP from its old name. You'll want to get that form from the clerk, fill it out completely. You'll be signing it under oath, and then you want to return it to the clerk. If you do not appeal by your deadline, you must vacate the unit within those 5 days, or the writ of possession can be purchased, issued, and executed. Now, if you do decide to appeal and you're being evicted for non-payment of rent, within 5 days of filing the IFP form, you must make 1 month's rent payment into the registry. The individual court will tell you how they accept those payments, and when their court closes, if they're going to take cash, check, money order, credit card. So you'll definitely want to make note of that, keep that, and return back with the money within those 5 days, because if you fail to make that payment, a writ of possession could issue after that deadline. After you file your appeal form and make your registry payment, your case will be transferred to the county civil court at law downtown, and it'll be assigned to a court. You will receive paperwork in the mail, so check your physical regular mail, check it regularly. In certain situations, if you have filed the appeal with an IFP form, you may not need to file a separate answer. In non-payment of rent cases filed with the inability to afford court cost form, you will have to make monthly rent payments, and those payments must be paid into the registry as they come due, which for most leases is usually the first of the month. So you'll definitely want to keep that in mind. Failure to make that rent payment may cause you to lose possession of the unit, even though your case will still be set for trial. So when you're in county court, the case will be heard de novo, which means from the beginning. So anything that happened in the justice courts, kind of they're voided out. They don't matter. The justices of the peace courts are not courts of record, so there's no need to tell the judge what happened last time or the other judge said this. This is a brand new case being heard from the beginning. And county courts use formal rules of procedure and evidence, so both parties have to approve up any of their testimony with evidence. And so anything that happened before doesn't really apply. So be sure to pay attention again to what your landlord, what the plaintiff is doing in court or what they had said before, because they must start over and prove their case up with testimony and evidence. So both parties are held to that same higher standard. If you're unsuccessful in county court and judgment is issued for the plaintiff, you will have 10 days to appeal or pay the appeal bond. However, the writ of possession can still issue in 5 days if requested. The cost of an appeal out of county court is usually 10 times the monthly rent, and it's due in a lump sum. So as a note, some courts will allow for an immediate writ of possession to be issued after the trial if you do not make your monthly payments. So as those payments come due, if you want to preserve some of your rights, you'll definitely want to make those payments into the county court registry. Now, another special case is for people who are in public housing or in subsidized housing. So public housing and subsidized housing programs, including Section 8 housing choice vouchers and low-income housing tax credit properties, have additional terms and requirements. So these requirements are spelled out in the HAB contract I can't remember how HAB stands for at this time, in the HAB contract and the federal regulations, depending on the program. So this is another reason why, when we said at the beginning, get a copy of your lease and all the addendums. If you've signed anything regarding to your housing situation, you want to get a copy from your landlord. So if you know you signed 5 different packets and your landlord says, oh, here's your lease, and it's only 1 packet, make that request in writing. So you have all those addendums, because you may have additional rights. The landlord may have additional requirements that they must reach, or different thresholds they must reach in order to even begin to terminate your lease, and you'll want to know that. Evictions involving public housing beneficiaries may also involve termination of housing benefits. So you definitely want to be careful. If you are evicted under certain terms, you may lose your access to housing voucher benefits. Again, public housing beneficiaries are covered by CARES Act protection. So if you are in one of those properties, you should be given a 30-day notice to vacate. Public housing beneficiaries and non-payment of rent appeals are only responsible for paying their portion of their rent into the court registry. If the court orders the full amount of rent to be paid into the registry, you may contest that order within 5 days. So this is another reason why I say to listen intently when you're in JP court. You want to hear what your landlord's saying, and you also want to know what to tell the judge. So if your landlord says, oh, the rent's $1,000, and they just leave it there, knowing that you are on subsidized program and your portion of the rent's $100, you definitely want to let the judge know, maybe the base rent's $1,000, my portion of the rent is $100, just to make sure that the order remains clear that your portion is the only portion you'll be responsible for. And like I said, if you do have an issue with that and you don't know how to contest it, please reach out to a local organization if you need help filing that paperwork. The terms and tenant protections differ between each program. So if you're receiving public housing benefits and facing termination or eviction, please seek legal assistance and definitely get and keep a copy of your lease for them to review as they work to help solve the issue. So what else might happen when the lease is breached? These aren't necessarily things that should happen, but they may. If you deal with a lockout or utility shut off, and you know that these are not bona fide repairs, construction, or an emergency, you will have access to the legal process. Because your landlord cannot intentionally exclude you from your unit via lockout, and your landlord cannot intentionally interrupt your utility services. Now, for lockout specifically, if your lease states so this is not an automatic right that every landlord has. But if a tenant is behind on rent and the right to change the locks is in the lease and proper notice has been issued, your landlord can lock you out in certain situations. However, and we'll go over that in a minute, they have to let you in certain situations. Your landlord can also lock you out if a judicial process allows it. So if they did an eviction and it was proper, and they got rid of possession, they can lock the door behind you, for example. So for lockouts and utility shutoffs, even if you're behind on rent, you do not lose your ability to sue to get let back in or for utilities to be turned back on. Even if you're behind on rent, you have access to judicial remedies if your landlord intentionally and illegally locks you out of your home or shuts off your utilities. Both of these are going to be ex parte lawsuits. If you're locked out, the lawsuit that you'll be searching for is called a writ of reentry. If you're dealing with the utility shut off, the lawsuit you'll be going after is a writ of restoration. You must file the lawsuits in the precinct where you live. So you'll want to make sure if the house resides in precinct 1, you file in precinct 1. And if you cannot afford to pay the court costs, you can file your petition with the inability to afford court cost packet to waive some of those fees. When you've been locked out, your landlord is required to let you back into your unit once you have requested to be let back in within 2 hours of the request. This is regardless of the time of day, and they cannot demand payment in exchange for the key. So if they show up and say, hey, we're here, but we're gonna need $100, absolutely not. This is prohibited under the Texas Property Code. And if your landlord fails to let you in and you remain locked out of the unit, that's when you can go for the writ of reentry lawsuit. This is correct. Writ of reentry lawsuit to ask the court to let you back in. So an ex parte lawsuit means that your landlord doesn't need to be served prior to having a hearing in court. So once filed, you contact the court for the case to be set for an ex parte hearing. If the judge agrees via your testimony and evidence that you were illegally locked out, you will receive a writ of reentry, ordering your landlord to let you into the home. That's the document that you must have served on your landlord. In the case that you've been locked out illegally, damages can be recovered in a suit. The civil penalties are 1 month's rent plus $1,000, any actual damages or expenses. So if you had to stay in a hotel or rent a room somewhere, then those are considered actual damages and expenses. Court costs and reasonable attorney's fees minus any delinquent rent or any sums under your ledger. You can also petition the court for termination of the lease. That is an option available. When your utilities have been shut off, if your utility services have been disconnected illegally, you can file a lawsuit in the precinct where your home lies. The lawsuit, like we said, will be the writ of restoration lawsuit in the same precinct where the home resides. The case will be set for ex parte hearing. If the judge agrees via your testimony and evidence that your utilities were disconnected illegally, you will receive a writ of restoration. Now, this is what you'll serve on your landlord. This orders them to restore the utilities. And then the case can then be monitored. If your utilities aren't turned back on, you can petition the court for additional assistance. You can recover damages in a utility shutoff as well. You can recover actual damages. So for example, if your water is shut off and you had to buy 5-gallon 5-gallon tubs, 5 of them, to cover the 5 days they were out. You'll want to keep those receipts because those are considered actual damages. You can recover actual damages, 1 month's rent plus $1,000, reasonable attorney's fees and court costs minus any delinquent rent or sums due to the landlord. Now, as a separate issue, we just like to bring up that the security deposit is separate. Security deposits are taken in to deal with any outstanding costs dealing with anything outside of normal wear and tear and damage, or uncovered fees. But these are considered after move out. So your landlord may keep and deduct from the security deposits amounts for damages and charges for which the tenant is legally liable under the lease or as a breach of the lease. Your landlord has an obligation to refund the security deposit on or before the 30th day after the tenant surrenders the unit. And your landlord cannot retain any portion to cover normal wear and tear. And if your landlord decides to keep all or part of the security deposit, they must send you a written description and itemized list of all the deductions, unless the tenant owes rent and there's no controversy concerning the amount of rent owed. For example, if you have a judgment for $5,000, and there's no controversy, there might be a situation where your landlord keeps a $1,000 security deposit. But again, this timeline doesn't start until you've moved out. And in order to get your security deposit or that itemized list telling you where your security deposit has gone, you must give your landlord a good forwarding address, and you want to give it to them in writing. So some additional tips as we round out my presentation. Get ahead of the problem. If you know that something's happening, emergency pops up today, the 20th of May, and so you know by June 1st, it's going to be a little hard, talk to your landlord as soon as possible. Talk to your landlord because they're humans, they understand as well. You might get some resources or even some additional time. If you're getting anything like that, you definitely want to get it in writing. But don't be afraid to get ahead of the issue. It's much harder after an eviction is filed to get results than it is if your landlord's kind of on the same page with you. Rental assistance may be available in your area. Check your local organizations or churches. Again, also, your landlord may have more information about what's in your area than you do. Another great reason to talk to your landlord ahead of the problem. And of course, if you're having issues with the condition of your unit, pay your rent first, then immediately contact someone for help. The timelines start and there are set timelines. And so you definitely want to reach out as soon as possible if you do want to pursue any type of lawsuit or any type of issue you're having with the conditions of the unit. Okay. So that is the end of my presentation. You can reach out to us, Lone Star Legal Aid Eviction Resources. You can go to texaslawhelp.org. Ben's email still on there. You can also email him if you have any questions, but my email is kdike@lonestarlegal.org. And if you would like to apply for services, please find us at lonestarlegal.org or call our toll-free number 1-800-733-8394. And if you're in the Texas area, Monday through Thursday, you can call at 713-652-0077. And that's it for my presentation today.
All right. I don't have any questions in the chat, but for the folks that are on Zoom, if you do have any questions, feel free to type them in or unmute yourself and ask your questions directly if you have any. I'm also still monitoring the social media channels as well. But in the meantime, I had a quick question for you. I had heard something about a state bill or Senate bill or House bill about a proposed change to the eviction process. Can you speak to that, or or like what's kind of being proposed or what's out there of how the eviction process potentially could be changing?
I am not well versed on that, so I can't. I think it is still being considered, and so I don't have enough information to give that'll be more than an opinion, which is not going to answer any questions. So,
Oh,
yeah.
got it. Now, as this? Is it something that's going to be voted on by the public or something that's just going to be passed? Do you know?
I don't know, actually. That's a
For those
legislation process that I stay in my branch.
for those folks that are not aware, I know that there is some proposal that's at the state or at the Senate level. I can't quite remember, but there is a proposed process on how evictions is supposed to be done now that's going to basically almost completely alter everything it is that you just said and what this process is going to be. That they're not going to be required to actually have to take you to court in order to have you evicted. So I do know that much is what the proposal is that's going to be changed. So definitely do some research, kind of contact your local your local legislators to get them to
Mhm.
or look at least into more information about what's potentially going to be happening here, and
Yeah.
it's not going to be good for tenants at all, just as an FYI.
Mhm.
So there is some proposed legislation that's out there. So um and I really need to look to see when it's supposed to when they're supposed to vote on it.
Yeah, there's a lot of timeline shifting and
Yeah, yeah,
conflicting information.
and I almost think
It's
that
something to
again,
keep in mind, though. It's something to just keep in mind if you're dealing with constant issues with having to pay your rent, and other violation of lease issues, you definitely want to just be aware that things are going to change. It's not going to be things are just going to change,
yeah.
or maybe not.
Well, and but this is the reason why we also do this presentation live as well, so that we can get the most up-to-date information as laws and processes change, because we're not always well versed or aware of, as much as you guys are required to keep up with it as they change than what we are. So again, that's why we kind of want to make sure that we kind of get the like bring the most accurate information to the forefront for folks in case they were not aware of what's
Yes.
going on, so that they can kind of start to do some research and kind of be conscious about that, or even at least try to get information out to other people so that they are also aware as well. So again, if you guys do find yourselves in need of any of this free legal assistance, do not automatically discount yourself and assume that you do not qualify for their service. We do encourage you to apply, and do not wait until the last minute. For some reason, the last couple of weeks, we have been getting a lot of phone calls from people, and I believe 211 has been given our information out, saying that we provide rental assistance, and we actually do not. It is the information that is provided on these workshops that we are offering, and the referrals to our legal service partners for any legal assistance. If you are finding yourselves in need, please reach out beforehand. Uh, I think the last call I got was like last Thursday or Friday. She was due to show up in court on Monday. So it's like,
Yeah.
yeah, why didn't you say anything prior to right now to receive some kind of assistance at that point? At what point is it too late for you guys to be able to do anything if somebody's waited to like the last minute like that?
That's usually it. We do have limited staff and resources. We do attend some courthouses, so you might be able to run into us on the date of trial. But a Friday to Monday is very dangerous, because if we don't have the resources to even review your case at that time, it's just um,
Too short
the
notice.
turnover is too quick. And also, evictions are very fast. I think it might be May 20th now, and you might see June 4th on something and think you have all the time in the world. And June 4th is not that far away. Evictions are usually going to be held, depending on the courthouse and how their docket is, between 14 and 21 days after filing. And so it's like I always tell them when I give this presentation, don't freeze. Let that citation activate you. Even if the notice to vacate giving you 3 days to move made you freeze because your brain is figuring out how I'm going to move my family in 3 days, a little freeze there I'll let you have. But if you get served citation and you know that your landlord has moved forward with that next step, as soon as you're given that document, read through it, look at the resources in your area, contact Lone Star Legal Aid, contact any other, of the Eviction Defense Coalition members that you mentioned in your introduction, because you want to give us as much time to find the staff and resources. Because let's say you applied 2 weeks ago and we might not have it then, but then we find out, oh, maybe you were going to your court, or, maybe we can look and see if we had some applicants we missed. We might reach out. You might find us in the courthouse and you might be looking for you. So the sooner the better. Yeah, evictions just move extremely fast. Like we said, your first deadline is 5 days after your court date. And so evictions are definitely as soon as the situation hits, talk to your landlord, talk to your organizations, get everything you can, because yeah, when you're a day or two out, we're good, but we're not we're not always that good.
You don't have any
Because
people.
we
You
don't
don't
have
have
the people, we don't
the
have the
capacity.
bodies,
Yeah,
like
yeah,
some dockets have 70 cases in one morning. And I love to do as much as I can, but some of
yeah.
even the courts have cutoffs for, how much time they can give. So everyone be encouraged to reach out, be encouraged to apply for any and everything, and don't be discouraged. We're in a big city, resources run out, but resources are replenished. So don't be discouraged. Hit the ground running as soon as you know there's a problem. Um, because yeah, as resources go down, as people, you know, get tired, as
Yeah.
summer's coming, it's hot outside. um,
Yeah,
you know,
there
you
there
don't want.
usually there usually are some other kind of organizations that do provide funding sources as well to help with rental assistance. I try to stay up, and try to look up as much as possible if somebody does contact us to reach out to different organizations. But it is all based on what the availability is. So there are some organizations. Private organizations that actually have funds available, based on the donations that they also receive, uh, or the funding that they also receive. So you just never know. They may not have it this month, but they may have it next month or something like that.
Correct.
So, but you have to continue to kind of reach out and kind of stay on top of those things like that. So let me ask you this also, and just to kind of reiterate, when people receive that notice to vacate, or that 3 day notice, 5 day notice, or whatever, that is not the eviction itself. So from the time they receive a notice to vacate, realistically, what's the time frame, if all goes on according to schedule, the least amount of time that they actually have from the time they receive that notice to the time they actually have to leave the premises? What's that timeline look like?
So it depends first, but first things first, it's always going to depend on your lease and who your landlord is. So if your lease, certain leases give 24 hours, some leases give 5 days, all that. So I'm going to talk about not from the time you receive the notice to vacate, but from the time that the notice to vacate deadline hits. So if you're given 10 days, on that 10th day, starting on that 11th day, your landlord can file the eviction. Likely that the case is going to be set within the next 3 to 4 weeks. Um, if you if you don't appeal and you go to trial on that third or fourth week, then you'll have 5 days to move out of the unit. So from beginning to end, it'll be about in the most simplest of situations, just that timeline between when the case is filed and when it's heard in court. Excuse me, and like if everything, I don't want to say perfect, it's not always perfect. And also there's never a perfect eviction, right? Because if there's rental assistance available. If you appeal right now, again, timelines differ depending on what's happening in that appeal timeline. But between those two deadlines, from the time those all paperwork and registry payments are done, cases are usually set between 5 and 6 weeks out. So I'll say that you might get an additional 2 months, all depends on how fast your court moves, what paperwork is filed, and then of course, the sheer volume of what the county court may be having to schedule, as well as Summertime's coming, so a few holidays here and there. So from the deadline of your notice to vacate to the end, it could be about a 60 to 90-day process if you appeal.
So there are some kind of remedy that it's not the 3 day. I get my notice and I only got 3 days to move out of my apartment or find some new residence to actually stay.
Correct. We call it self-evicting if you have nowhere to go. Um, there are, of course, pros and cons to every lawsuit. But if you have nowhere to go and you're in July heat in Houston, you can wait until a writ of possession is completely issued and executed. But if you have not talked to your landlord prior to getting that notice to vacate, I would talk to them as soon as possible. Sometimes the conversation itself, again, might yield some time or some resources that the landlord may be privy to. I also want to touch back when you're talking about rental assistance and private and publicly owned complexes or smaller versus larger complexes, you want to talk to your landlord ahead of time. Some landlords will not accept third-party funds and will require you to tender funds from your name. And so you definitely don't want to spend time filling out applications or working with programs that say they're never going to allow you to take the money to your landlord. So you definitely want to talk to your landlord ahead of time so that you know what their policies are regarding what information they're willing to give out in order to receive those funds and how they want to receive them so that you know where to focus your energy.
Okay. I'm trying to look on social media. Somebody had sent in a question. Okay. Blah, 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 blah. I believe that's all the questions that we got. Nothing. I was checking to see what was emailed to me too in advance,
Mm.
and I don't think I received anything there either. I do believe. Oh, you know what I did have a question about too? If someone actually, if they're at the end of their lease, or they don't give their notice, or they leave before the end of their lease is up, depending on what the lease says. I know you're going to say depends. uh, but if someone say they break their lease, or they have a couple of months, or they didn't give a couple of months notice, if you break your lease or don't give adequate amount of notice, are they allowed to, is a landlord allowed to sue you for the remaining months of your lease? In addition to them being able to rent out the place, aren't they then getting the rent twice for the same space? Are they allowed to do that?
So there is usually an acceleration clause that kind of says that they can. However, there is a duty to mitigate in the property code. So if they wanted to, because essentially, if they wanted to do that, they would have to leave the place vacant for 4 months, right? You left 4 months, like, I couldn't find anyone. And you'd have to prove to the court you couldn't find anybody. Did you put out any type of feelers or applications? Did you turn everyone down? Like, what were the, how how did their breach cost you money that you could never recover? So that's the test usually. So it's called a duty to mitigate. So if you move out, they have to figure out a way to put someone in there so that they don't have to come out. They don't have to come after you for those additional funds. So they might be able to put something on your credit, like if they had a liquidated damages clause or an early termination clause that applies a certain amount of money if you do X, Y, and Z. But if they just simply say, we're going to charge you that plus the rest of your of the outstanding months, then you do have remedies where you can put it in front of the court and say, I'm being charged, I'm being double charged, but I know someone's been in there for 3 months. And then it'll be reviewed like that.
If you so happen to find yourself in one of those situations and you can't find, because I know a lot of people don't keep a copy of their lease. They don't keep it for whatever reason. And can they still request, or that is the landlord then required at that point, or what's the process if they need to get another copy of that lease? Are they required to then provide them with another copy if they don't have theirs, or if they request it?
Yes. So what you would do, it's like any demand letter. Because the Texas Property Code has specific, we have a statute saying if I request my lease in writing in this manner, you must give it to me within 3 days of my request. So just like any other lawbreaker, if you don't give it to me, I can sue you. And I can say that I'm trying to enforce this rule that says he needs to give me my lease. And so that's how I would do it that way. And of course, go to for everything. If it's in your email, it's in there. Because if you send it to yourself, it's in your inbox and it's in your sent. So I would say if you do get a copy, save it to your email, and then you can always have it somewhere to be pulled up. But yes, Texas Property Code does require landlords to give you a copy of a document that you sign. It's a binding contract. It can't just be floating in the air without,
Hmm.
you
What do
having a
you do?
copy.
What do you do in the event if the ownership changes or they change property management companies?
Property management companies those can change within your lease
Mhm.
term. They still take over the property as management. They essentially, they bought the baby. And so if you want to request your lease through them, you can do the same thing. It's all the same process. They're going to be held to the same standard because they can't just take over the property and say, we're starting over. And it's like, okay, well then do I not pay rent? Like, how much are we starting over? So
Gotcha.
keep
I
that
think
open.
I think a lot of people kind of lose that in the transition too. They just automatically assume because it's a new owner or a new property management company that there is no remedy, no recourse, that they can't get access to any of that information, and they
Correct.
can't.
But that's the other thing. That's the dangerous thing about not getting it upfront the first time. Um, like I said, once you sign it, your landlord is required to give you a copy within 3 days. If you don't receive one within 3 days, immediately go and ask for one in writing. Send the email, send the text message, however you communicate in writing, do that. Um, so that because I've seen it all, right? I've done this for a little time now. I've seen places that don't have copies of the original lease when they sell it to a new owner. And you will be dealing with a person that says, I don't know. I just knew that the computer said you're here until July of 2025. And so I wasn't going to give you a new lease until August of 2025. And they were going to, call it a wash. So definitely want to be careful because all complexes are not created equal.
Are they required to give you a copy of your lease before you actually move in? So say if, for instance, it's you're moving in June 1st,
Mhm.
and you've already signed your paperwork, but you don't have that executed copy back because the landlord hasn't signed their part or what have you. So are they required before you actually move in that you're supposed to get an executed copy, or can they wait till after you moved in already?
So the code says within 3 days of all parties signing the document. So that would all depend on if you move in June 1st and then you realize you signed it on May 20th and they signed it on May 22nd. Why didn't I get it by, May 26th? I shouldn't have to wait till June. So that's what I would say. It's all about when it's fully executed. So when both parties have signed it, start looking for your copy. You know how I feel like DocuSign might send an email that says, oh, all parties have signed, you now have access to it.
Yeah.
Download it immediately or ask your landlord for a copy immediately if you don't have the ability to download it in that
Mm,
form.
okay. I just almost feel like sometimes that those documents are actually like left blank. Like if you as a tenant sign, but the landlord hasn't filled in their spaces, can they put in some information after you signed it that you didn't agree to before it was in there?
And that's where contract law and the way changes must be denoted and things like that, that's where that would come in. And another reason why you want to read that bad boy from beginning to end. Just don't know what the words mean, but just know that the words are there.
Mm.
So it's just very important because, like I said, not all landlords are created equal, not all complexes are created equal, and the best way to protect yourself is to just know what you're getting into.
Okay, another question here. Once a tenant goes month to month, can a landlord start the eviction process?
So once a tenant goes month to month, in Texas, both parties have the right to terminate the lease. So it's not an eviction process until after there's been a termination, and then the tenant decides to stay. Whether I terminated it in 30 days and then didn't move out, or you terminated in 30 days, we're not fighting for possession until after that deadline. So starting the process of giving you a, hey, I need you out in 30 days. And then after that 30 days, they say, hey, you're still here. It's day 31. You have 3 days to move out before we sue you. That's kind of how they started. But can they evict you immediately just because you're month to month? No. There has to be a breach or a termination by either party first.
If a landlord does not provide a new lease after the old lease has expired, can you demand a new lease?
So demand's a tough word. Yes and no, because you cannot force a landlord to renew on a term that only you have decided. If both of you want to enter a 60-day lease, or a 6-month lease or 12-month lease, then both of you can enter that. If a landlord decides that he wants his property to remain a month-to-month property, he can also decide that. And if you don't like it, you can, ask for the lease to be terminated. But I don't believe you can simply demand a new 12-month lease.
Because
Just
being the
because one
being
expired.
because being month to month, at that point, you're subject to him saying, "Yep, next month I decided, yeah, we want you to go ahead and go and be gone," and then that's pretty
But
much
he's
it.
also subject to
Or
you doing that too.
to that, right? You could decide, oh well, next month I don't think I'm going to be here anymore, and I'm going to go ahead and just move. So
Yeah. And so that's the beauty of it, because the same way you can lock me in for 12 months, I can lock in my price for 12 months, because that's what the lease is, right? Because month to month, if they give you 60 days notice that in 2 months of your month to month it's going to increase to X amount, they are allowed to do that as well. So there's a lot of pros and cons to how you decide to contract. But as far as demanding a new lease, it all depends. So if you have your first lease that ended for term with no month-to-month rollover, then your lease has been terminated and you might be considered a holdover there. If your lease automatically rolls over month to month, and you're like, oh, I don't want to be month to month, I want a 12-month lease, both parties still have to decide on that 12-month lease.
why is it in a lot of the leases or a lot of the generic ones, I see that a tenant has to give a 60-day notice to move or that they're not going to renew the lease, but a landlord can give you 30 days notice to increase your rent. Why is that? How is that fair? Like you're not required to give me 60 days notice like I'm required to give you 60 days notice. Why? I don't understand that part either.
And
And I
my
know
polite
it just kind
answer
of
is,
depends.
well, no, it's
Depends.
not that it depends. My polite answer is that it's the landlord who wrote the contract. That's why it looks
Yeah.
like that. It's drafted by the party, that's because
Yeah.
if you wanted to, again, feel free to ask, because just because it's typed out doesn't mean it's etched in stone. That 3 can be blotted out and made a 6. If you ask for it, if you decide on it, if both parties are in there. That's why sometimes I'm also very, which is old school, I don't want to reveal my age, where I'll go into the office. I will hand sign something simply
Yeah.
because I know I don't want to hear someone say, oh, we'll send it back and we'll edit it. And let's edit it when
Uh,
we're both looking at each other, having a great day,
yes.
laughing over my free coffee from the break room. Like, that's kind of where you can start crossing things out initially,
Yeah.
just for me, it doesn't need for everybody. It doesn't need for everybody. We're not talking about, room A. We're talking about room C. So let's do it here. So that's where those changes and edits can be made. Those are the, times where feel free to be personable and go inside and, ask questions. Like, I ask for a concession every year. Do they tell me no? Yes, but never not going to ask.
Can you require that you get a hard copy of a lease to sign and not have to sign it electronically? Like if I want you to print it out and I want to be able to sit here and read through it, that I'm not computer savvy. I don't want to sign anything electronically. I need to see my lease. Can you require that?
So And it's funny because I feel like the property code does address this because there is a section of it that if you have already contracted previously via email or via digital copies, it's almost like they can't be forced to print it
At
because
that
you,
point,
yeah, at that
because you've
point,
already
because
done
you've
it
already,
before.
correct. Let me find it real quick. Let me go to the,
Okay.
but
Uh,
but yes, if you've already done a certain amount of virtual contracting, they won't, because of the cost of printing, you know, which is insane to me.
well,
Might not
all
have
right.
to.
While you're looking that up, there's a question here. If you have permission from the landlord to make improvements to the property after the lease ends, can you ask for compensation for those improvements?
Ask it again.
If you have permission from the landlord to make improvements to the property after the lease ends, can you ask for compensation for those improvements?
You'll want, I'm gonna say no off the top of my head, but the point of discussing it ahead of time is to make sure before you make those improvements, you know if they're going to compensate you. Because most of them will say no. If you want to, well, most of them will say if you created a fixture in their property, you actually
It's
breached their
theirs.
contract. Correct. Or they get to keep it.
Yeah. So ask before and put it in writing before.
And put
Don't
it in
just
writing
have
before.
and put it in writing before you make any kind of changes and if they're going to compensate you afterwards. Or if you make an improvement, then you take it out, then you're responsible for the repair. So if you put in ceiling fans, but you want your ceiling fans back, you got to put it back the way that it was before you put the ceiling fans in. Just an example kind of thing.
Yes.
So yeah.
It's a good example because I want a ceiling fan in my office and they're like, you can for the low cost of, never mind, don't worry about it.
and
Don't
you
even worry about it. I got a standing fan right here. No.
and you can't take it with you when you go.
Right, thank you. I cannot. Okay, so yes. So a landlord may comply with this section by providing a tenant with a complete copy in a paper format, in an electrical format if requested by tenant, or by emailing if the parties have communicated by email regarding the lease. So, okay, so you can enforce and require them to give you a paper format copy. Yes.
Okay. All right, cool.
Mhm.
All right. I don't see anything on here, and I don't have any other questions in the chat. Are there any other questions from any of the participants
Thank you for your questions, Lonnie.
here? Yes, thank you for sure. All right. With that being said, again, this session has been recorded as well as broadcast live on our social media channel at AMOS Houston on YouTube, as well as on Facebook. We will be sending out a link of this recording in case you'd like to go back and watch the presentation again. We do encourage you to reach out to legal service organizations if you do, or if you are facing eviction for whatever reason and you need some legal assistance or advice or kind of guidance of what to do, please reach out. Do not wait until the last minute before you do to show up in court and not have any kind of representation. You definitely want to attempt to be able to do that if at all possible. So whatever resources that I do have available or whatever else, whatever other resources in relation to evictions or rental assistance, I will include that on the email as well. Again, you'd have to reach out to those different organizations to see if they do have assistance available at that particular time. You also can reach out to the United Way 211 and let them know that you are in need of rental assistance or utility payments. They do have a list of some organizations as well that do provide that type of assistance as well. If you, again, are in need or know of someone that may be and just don't know where to go to ask for those particular resources. So thank you very much, Kimberly. Really appreciate you taking the time out this afternoon. To all of our participants, If this is your first time joining us, we hope that you received the information that you intended to receive. For those that have come back before and joined us previously, we want to thank you for your continued support. You're very welcome, Mr. Lonnie. We definitely thank you guys for your continued support. At the end of this Zoom meeting, there will be a survey link that pops up, and we ask that you just take a couple of minutes to fill that out, just to let us know, hey, yeah, I got the information I received. Like, no, I didn't. I wanted more information. I needed this particular thing addressed. Please let us know, so that way we can make sure that we can do some adjustments. Or if there are any legal or any of our workshops that we don't currently offer, that you all find yourselves and say, hey, this is what's going on in my community right now, or this is an issue that's affecting me and my family right now. Can you guys give us more information about XYZ? Then please reach out to any of our a month of service partners and let us know. So as we're scheduling moving forward, then we'll know what to provide for you guys in the community. So we'd love to hear from you. Again, thank you all very much for joining us this afternoon. Kimberly, once again, wonderful job. Thank you very much. Really appreciate it. You all have a wonderful remainder of your day. You take care of yourselves. You stay safe, and we will see y'all next time.
All right.